Oh, hey friends, it's Josh. Doing a walk and talk. Thought we'd do a quick review of those items that should probably be looked at and updated in mom and dad's estate plan that hasn't been read in 15 or 20 years. So this is not a new problem. Mom and dad are 75 to 85 right now. Their trust and estates attorney was their contemporary and is now retired or dead. And nobody has looked at mom or dad's estate plan in minimum 10 years and probably longer than that. So, when reading an old estate plan, what are the things that we're almost certain are going to cause trouble if the estate plan isn't amended in these particular areas or restated to accommodate new best practices? I'll just give you a little quick overview of the items that I look for when reviewing an old estate plan. Number one, does the estate plan require the mandatory funding of the bypass trust? Now, in the old days, when the lifetime exemption amount was much lower, $600,000, it made sense that if dad died first, a bypass trust would be set up. Dad's portion of the estate would be put into that bypass trust. That was mandatory funding. Didn't have a choice. Mom had to do it because it was good tax planning. But now at this point, with the lifetime exemption amount being pushing $14 million, $13.8 or something like that right now, mom and dad can, on a combined basis, give away more than $26 million. We don't need to fund that bypass trust. It's kind of a waste of time. And there are certainly exceptions to the rule when a bypass trust is appropriate, but trust me, they're the exception to the rule. The rule is it's mostly not needed for estates that are non-taxable. So when mom and dad's estate is less than $26 million cumulatively. Other things to look for, sometimes mom and dad name all the kids as co-trustees because they don't want to offend any one of the kids. And I think it'll probably just be better if we tie their hands together and make them do this complicated process or project together. Doesn't work that way. My suggestion is only have one of the kids be the successor trustee, and then have the other kids have the ability to remove and replace their knucklehead sibling if their knucklehead sibling is in fact a knucklehead. So like have one of them do it and put some provisions in there that make it easy for the other kids to remove them if it's not working out. Other things that we want to look for in trust documents, trustee compensation. A lot of times we've got a family member or a friend who's going to be responsible for settling the estate. Trust doc says the compensation of the trustee shall be reasonable, but doesn't actually say what that means. That person has their own use of time and value of time, and so may have one perception of what reasonable is. Beneficiaries or siblings may have another assessment. So having some guidance offered by dad on what the heck does reasonable mean so that we don't have long fights about it. Other things for the trust doc, what else should we consider within it? There's kind of a new provision in estate planning called the trust protector, a new role. That role has been around a long time in other jurisdictions, but it's kind of new to see it in California trust docs. Not that there was ever any prohibition around it, but anyhow. So there's somebody called the trust protector, and they have this limited power to do certain things like tweak the trust doc if the tax rules change, or remove the trustee if they're being an absolute knucklehead, or find a new trustee if there's a vacancy in the office. This party, the trust protector, doesn't have any authority to manage the trust long term. They just have authority to do these really specific tactile's the wrong word, really specific, let's say, targeted activities in the administration that sometimes are needed. So adding the trust protector might be something to consider. When I'm reviewing trust docs, I also look at the list of bequests that mom or dad had. They want 100 grand to go through to a school or a church that they no longer have a relationship with. Haven't been at that place for 50 years. But the document was written a long time ago, and that's what they wanted 25 years ago, and so that's still within the document. So do a quick review of the beneficiaries of specific bequests, particularly interested in charities. Do the family still have the same relationship with the charities? Sometimes there's family relationships that mom or dad no longer want to fund these minor gifts to nieces and nephews who are now in their 50s and 60s, etc. So those are some ideas for things to look at when reviewing a trust doc. Get those reviews done. Each one of those can add time and hassle to the administration. And if it's done right ahead of time, it can dramatically reduce time and cost. So let's get those trust docs reviewed for mom and dad and make sure everything's up to snuff. I'm Josh with Anados Law, and our website is trustee-help.com. Trustee-help.com. Good morning.